Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's Happening with AI and Data Privacy? An update from the Privacy and Information Security Committee of the Antitrust Law section. It's a critical time in the development of U.S. privacy laws and the regulation of artificial intelligence. In 2025, the states made increasing efforts to protect consumers from privacy law violations and perceived unfair practices involving the deployment of AI. At the same time, a recently issued federal executive order directly challenges state-level AI regulation, purportedly to promote national innovation. As we look toward 2026, the complexity is only increasing. On today's episode, we have two special guests from the Antitrust Law section's Privacy and Information Security Committee, who will tell us why the next 12 months could redefine how technology is governed in the United States. But before we talk about that, I'd like to welcome my co-host, Anora Wang. Hi, Anora.
Hi, Alicia.
Would you like to introduce our guests and kick off the conversation?
Happy to. Our first guest is called Jessica Cohen, who is a Senior Counsel for Regulatory Affairs, AI, Cybersecurity, and Privacy at Verizon Communications, where she leads the company's legal and public policy analyses and advocacy response in areas including cybersecurity, privacy, and AI. She's a vice chair of the Antitrust Law Section's Privacy and Information Security Committee. Jessica also serves as a presidential appointee to the American Bar Association's Cybersecurity Legal Task Force. One more thing before I forgot and I should mention is that in 2025, Jessica was elected to the City Council of her hometown of Cleveland Heights, Ohio. Our second guest, Alex Brown, is a litigation partner in the Atlanta office of Alston Bird, where he co-leads the firm's consumer protection /FTC and state AG teams. His practice focuses on litigation, investigation, and counseling clients in areas of AI, antitrust, consumer protection, data privacy, cybersecurity, and telecommunications. Like Jessica, Alex is a vice chair of the Privacy and Information Security Committee of the Antitrust Law section. He previously co-chaired the section's AI task force and was a guest on Our Curious Amalgam in November 2022. Welcome back. So with that, and without further ado, welcome to Our Curious Amalgam, Jessica and Alex.
Thank you.
Thank you, Anora.
So let's jump right in, starting with Jessica. What were some key developments in the area of AI regulation in 2025?
Well, there was certainly no shortage of AI laws proposed. Some estimations have it over 1,000 state laws proposed in 2025 on some sort of topic of AI. And what's interesting is that even over the course of the year, we saw a shift. 2024 was the year of omnibus AI or anti-discrimination, high-risk use, AI use legislation. Many laws were proposed across the country, about 10 in 2025, but none of them passed. They were either vetoed, like in Virginia, where they were vetoed by the governor, or they failed to pass, like in California, where they tried for a second year in a row. So Colorado's omnibus AI anti-discrimination law remains the only one in the country. So that was an interesting development. We also saw a raft of name, image, likeness bills proposed, non-consensual intimate imagery, other efforts by states to incorporate AI into already existing statutes in things like non-consensual intimate imagery and child sexual abuse material. And so those were generally successful over the last year and supported mostly across the board. And two other things I want to mention just very quickly. One is we saw frontier model safety legislation, and we saw a big bill on that pass in 2025 in California. And just at the very end of 2025 in December, the New York version of that bill passed with some significant amendments from the governor. Lastly, because again, there's no shortage here, we saw some focus on AI liability. We expect that to continue. We saw a significant bill pass on companion chatbots in California, and we see that effort to continue. And we'll talk a little bit more about that, I think, later today.
Well, all of this stuff sounds like it's been ripped from the headlines. I know when I read the paper, there's always something about proposed regulation of AI or the social problems, that people point to AI as being the culprit. Alex, on a related note, the PRIS, Privacy, Information and Security Committee, has been actively monitoring developments in the area of individualized algorithmic pricing, or what some of us call surveillance pricing. This is something that I think crosses over and overlaps with AI and data privacy. What would you say are the most newsworthy developments in the past year on that topic?
Thanks, Alicia. Surveillance pricing, or personalized or individualized algorithmic pricing, was certainly a hot topic in 2025, and we expect that will continue into 2026. It really started in late 2024 when the FTC launched a 6B study into what it called surveillance pricing. Surveillance pricing, or individualized algorithmic pricing, occurs when companies use individual information about customers to charge different prices to different customers or customer groups, usually based on location, demographic information, purchase history, browsing behavior, things like that. Companies often use AI tools to process the data and set the prices. A preliminary report on the FTC's findings was published in January 2025, not coincidentally, just days before the Trump administration transitioned to power and the FTC changed over. The preliminary report had some interesting findings about the different types of tools being used. For example, some companies are using what's essentially a next-gen version of a targeted advertising tool to price differently to different consumers or consumer groups based on data collected about your behavior or characteristics. This could be anything from actual recent shopping history, such as you recently bought a first-class ticket or an expensive watch, or something more general, such as you have a Platinum American Express card and they know that you have some spending capability. The full study has yet to be released. We're still waiting on that from the FTC. In December of 2025, multiple media outlets reported that the FTC is investigating Instacart's use of the AI pricing tool Eversight, which it acquired in 2022. This pricing tool allows retailers on the Instacart platform to use AI to charge different prices to different customers, a practice that has sparked public criticism following recent investigative reports by the New York Times and Groundwork Collaborative. Although Instacart disputes that the tool was engaged in surveillance pricing, the public outrage at the company charging different consumers different prices for the same goods in the same location or store was real. Even though this sort of thing is commonplace when you buy insurance or buy a new car, the fact that it was being used in a retail environment where customers expect to be charged the same price as every other customer caused quite a bit of backlash. Instacart announced in late December of 2025 that it will cease the use of artificial intelligence-driven pricing tests on its grocery delivery platform after the public backlash. For listeners who want to learn more about surveillance pricing, I am moderating a panel at this year's Antitrust Spring Meeting on Thursday, March 26th. We have a great panel including Ben Fishman at the New York AG's office, Tatiana Rice from the Future Privacy Forum, and recent OCA guest Andrew Stivers, all prepared to cover and talk about AI and privacy implications related to surveillance pricing.
And we've also have a few Our Curious Amalgam episodes, at least one, perhaps two, on that very topic as well. And we'll post links to those episodes on this episode webpage for anyone who's really interested in the details.
More attention from the federal level and beyond just agencies. On December 11th, 2025, the White House issued an executive order titled Ensuring a National Policy Framework for Artificial Intelligence, aiming to create a unified minimally burdensome national standard to boost U.S. AI innovation, while directly challenging consumer protection legislation at the state level. What do you, Alex, I guess start with you. What do you predict will be the impact of this executive order in the AI and data privacy landscape in 2026?
Thanks, Anora. I think it's important to take a step back and kind of look at how the Trump administration's AI policy has evolved over the course of the last year. The White House focus on deregulation of AI started immediately after the Trump administration came in, issuing an executive order in January of 2025 to remove barriers to American leadership on artificial intelligence. Then we saw over the summer the One Big Beautiful Bill, which was passed over the summer, originally included a 10-year moratorium on state and local AI regulation. This moratorium was ultimately removed as it became clear that it lacked majority support. Also in July of 2025, the White House released Winning the Race, America's AI Action Plan. America's AI Action Plan required the Federal Trade Commission to, among other things, review all FTC final orders, consent decrees, and injunctions, and where appropriate, seek to modify or set aside any that unduly burden AI innovation. In connection with this review, the Commission determined that the public interest requires that the order issued by the Commission in the Ryder case be reopened and set aside. This happened in December of 2025 and is a rare but not unprecedented move by the FTC. The Ryder order was issued late in the Con FTC in 2024 and alleged that Ryder's AI writing tool enabled false or deceptive reviews. The order banned Ryder from offering AI services, generating reviews, or testimonials. The order was initially criticized by Republican commissioners because, in their view, Ryder was investigated because of what the tool could allow AI to do, not for any specific wrongdoing. Christopher Mufaraj, director of the FTC's Consumer Protection Bureau, said that it's essentially condemning a technology simply because it could be misused or is inconsistent with law and order to liberty. The Commission found the order failed to meet FTC Act legal requirements and unduly burdened AI innovation, violating Trump administration AI policy. Ryder consented to vacating the order and waived its rights under Rule 3.72b, which is the FTC rule, which allows the FTC and or a company to reopen, modify, and set aside final orders. The FTC will continue to hold accountable actors using AI to deceive consumers, and they made this very clear as part of the taking away the Ryder order. But they're going to be a little bit more careful about how they do it and really try to make sure that they're not slowing down AI development in the process.
Jessica, what are your thoughts on the impact of the executive order? And against all that background, are we still seeing more state-level AI legislation happening in 2026?
Yeah, I actually think there's a lot yet to be known and yet to be seen about what impact this executive order will have. And that's because we have a few key deadlines coming up. That'll be interesting to see what comes out of that. Milestones, 30 days from really it lands on January 10th, given when the executive order was issued. The Attorney General of the United States must establish an AI litigation task force. What that's going to mean for potential federal pressure on state AI regimes that already exist. For example, like the Colorado anti-discrimination law that was specifically named in the executive order, we will have to see. And we're not sure what direction the Attorney General and the Department of Justice will take on that. And that will have a couple days, and then they'll start their work. And then March 11th will be 90 days from the issuance of the executive order. Then at that point, the Department of Commerce is expected to publish an evaluation of onerous state AI laws that conflict with stated federal policy. The FTC is going to be charged with issuing a policy statement on unfair, deceptive, abusive acts or practices, application to AI, and other preemption claims. And then the FCC was also tasked, interestingly enough, because this is not an area that they usually are engaged with, considering a federal preemptive AI reporting and disclosure standard based on the Communications Act. So all of this is fairly new and interesting to those who are in the field. We obviously have never seen this framework before, and we're not sure where the agencies that are mandated by this executive order for action will take their mandates. But what we can say for sure, just having the start of some state sessions in the last 2 days across the country and expecting many more state legislatures to open their sessions in the coming weeks, is that this has not slowed down the pace of AI legislation that is being introduced. We are seeing already lots of state legislation being introduced on surveillance pricing. We're seeing a focus on AI liability. We're seeing more of a focus on frontier model safety as a continuation of California and New York. And we're definitely going to be interested to see if states will continue to try to pass this anti-discrimination AI legislation as they now have in law in Colorado, or if last year was effectively an indication that those laws are not going to work for business and innovation and are not necessarily the ways that consumer rights groups want to move forward, and they'll pivot to another area. One more note on this is, we could talk about this a little bit with privacy as well, is that children's privacy and children's safety online continues to be a growing concern of state legislatures and state legislators across the country. And we saw that starting last year with these companion chatbot bills. We've seen some high profile cases in courts across the country of children that have been harmed or unfortunately committed suicide, and questioning the liability of AI products in that area. And so legislators are now looking to see how they can regulate companion chatbots. As I mentioned, California passed a law this past year in 2025, and we've seen a number of states pick that mantle up and trying to pass a bill. Last year, we did have a few that were successful, and we expect that this will be a real focus of states in 2026.
Now, I think a lot of us assume that the AI regulation is something that's going to be a big concern to big companies, big tech, companies like yours, Jessica. Alex, you're in private practice. Is this something that other companies need to be concerned about? Who should be keeping an eye on everything that's going to roll out in the coming year?
Absolutely. No, it's not limited to just the big companies and the companies that are, developing AI, large language models, but really anybody that's using AI needs to be careful about how they use it and how they market it. And while Jessica's absolutely right, it's very unclear exactly how all of this state AI legislation is going to turn out and what additional regulation there's going to be. The existing legal landscape has been and will continue to be used to regulate the use of AI by any company. So, you have to be really careful about the way that you market your use of AI. You have to be very accurate about the capabilities of AI tools. We've seen many examples from the FTC and the states where companies have gone out and said, oh, we're using AI for this, and that's going to make it so much easier. And the claim is simply not true. And the company is, facing enforcement under, traditional unfair and deceptive trade practices laws, the FTC Act or the state law equivalent. So any company that's touching on AI needs to be aware of the new potential requirements under the state laws, and also just making sure that the day-to-day use, the way that it talks about its technology, the way that it uses data and pulls in data is compliant with the existing consumer protection and data privacy laws.
Well, that's good to know, and it's good to know that your committee is on the job. Now, the other big mandate of your committee, of course, it's not just AI, but also data privacy. So, as we look back on 2025 and look forward to 2026, Jessica, what were the highlights back then, and what do you predict going forward?
Sure. So on 2025, the big news headline was that for the first year in many years, I believe since 2018, there was no state that passed a new omnibus data privacy law in their state. Interesting. We have 19, 20 if you count Florida, which some people do and some people don't, already across the country. We did have a number of states continue to try to pass the omnibus data privacy laws in their states, but they either didn't make it over the finish line in time or were hotly opposed for having some significant outlier provisions that would prevent interoperability with other state privacy laws. And so we'll soon see in 2026 if states like Pennsylvania will pick up the mantle and try one more year to get a state privacy law across the finish line. But we have seen a bit of a coalescing of that interoperability across the country, with the exception like states like Maryland, which has a unique data minimization provision. There was a small effort in 2025 to quote unquote fix that by industry, but that also failed to cross the finish line. So we pretty much have the status quo when it comes to omnibus data privacy laws in 2025 across the country. One big focus where we did see a lot of movement and interesting movement was children's privacy. No surprise, because children's online safety was a big priority last year. And two avenues that legislators pursued. One is in the tradition of California, age-appropriate design code. Of course, that law in California underwent significant legal scrutiny over the last year or so, and was at least partially enjoined. So that we thought might be a signal to other states that this is not the direction to go. But we saw states like Nebraska in 2025 pass an age-appropriate design code law, as well as Maryland and a few other states. Of course, New York also had a children's privacy law in 2025 as well. The other path that some states took was to pursue App Store bills. And this was really an attempt to shift the obligation for age verification from apps themselves. If you imagine you could have 100 apps on your phone or 50 apps on your phone, all of them having to verify age, shift that to the app stores themselves. It was a new take on children's privacy. It's one that industry engaged in quite a bit from all sides. There was not unanimity across industry on how these bills might work in practice or whether they would be effective. And Texas was one of the states that passed one last year, in addition to Utah and one other state. Texas was supposed to go into effect on January 1st. It was promptly, the state of Texas was promptly sued as soon as this bill passed. And just 2 days before the holidays in December 2025, federal district court did issue a preliminary injunction blocking the App Store Accountability Act in Texas from taking effect. So we will see. I believe that that decision is already under appeal. We will have to see how that goes. And on the other side, just a quick note is that when it comes to age verification, we saw Supreme Court ruling in Paxton that the age verification when it comes to pornographic sites is considered constitutional. And so that's a Supreme Court case that a lot of folks are going to be looking at as a signal for what's going to happen in the courts around these children's privacy laws in 2026. I'll just say on the state side, we expect states to continue to work on this. This is a priority of many legislators, both Republican and Democrat. And will be interesting. It will be interesting to see where we end up, and particularly as these court decisions continue to come out from across the country.
definitely interesting to see how privacy legislation or I guess any related enforcement is happening at, I guess, different rates or in various directions in various states. But what about FTC's role? What is the federal agency doing all of this? Alex, perhaps you can tell us what FTC has been doing or not doing in areas of data privacy recently, and what do you think the agency is headed to in 2026?
Well, after the transition from the Cohen FTC to the Ferguson FTC, we saw an increased focus on an area that was already a big focus, and that's children's privacy. Again, as Jessica mentioned, it's a bipartisan issue. So some of the more partisan, privacy enforcement that was going on in the Cohen FTC kind of went away. And the Ferguson FTC is really focused on children's privacy. We saw in April of 2025, the FTC published amendments to the Children's Online Privacy Protection Rule. Companies have until April of 2026 to comply with the amendments to these rules. Among other things, the amendments will expand the scope of personal information protected under the COPPA rule to include biometric identifiers. It will require operators to obtain separate verifiable parental consent before disclosing personal information collected from children for purposes that are not integral to operators, websites, or online services. And it will also mandate operators to establish, implement, and maintain a written information security program and written data retention policy. Again, these changes are going to be in force in April of 2026. So if your company or platform touches on children's privacy or had potentially markets to or includes children, these are things that you need to be focused on in the first quarter of 2026. A recent example of COPPA enforcement by the FTC is a lawsuit filed in September of 2025 against Sendit, which is an anonymous messaging app popular with teens. The FTC alleged that violations of COPPA, the FTC Act, and the Restore Online Shoppers Confidence Act, or ROSCA. According to the complaint, Sendit collected personal data from kids under 13, things like phone numbers, birth dates, and location, without parental consent, despite knowing that thousands of its users were underage. The FTC claims in the complaint that the company sent fake, often provocative messages to boost engagement and misled users into buying subscriptions that promised to reveal message senders, but didn't actually deliver on the promises. Even worse, these subscriptions allegedly auto-renewed without clear disclosure, which is an alleged ROSCA violation. The FTC is seeking a permanent injunction, civil penalties, and monetary relief. This case underscores the agency's focus on protecting children online and cracking down on deceptive billing practices. Companies targeting young audiences should expect heightened scrutiny around data collection, not just from the FTC, but also from state enforcers. We've seen the same focus on children's privacy, enforcing the existing laws in those states all around the country, everywhere from New York to Texas to California, and everywhere in between. So children's privacy is going to continue to be a big area of focus.
And Anora, I'll just add, if that's okay, that companies and other lawyers should be looking at Congress in 2026. The House Energy and Commerce Committee in December 2025 began a markup of 18 different children's privacy bills, and that markup, we understand, will continue either this month or next. And so lawyers everywhere will want to be tracking that to see, we could see COPPA 2.0 come out of that markup, the Kids Online Safety Act that's been in Congress, considered and attempted to move forward a number of times, among a number of other laws related to children and technology. And then lastly, for those that are watching state regulations, we're still waiting for New Jersey's privacy rules to be released. And so folks will want to keep an eye out for that as well.
Well, this has been an episode bursting with information about incredibly hot topics of the day. And obviously, there will be a lot more to talk about as the year goes on. Hopefully, we'll maybe get you guys back at the end of next year. We can compare your predictions to what has actually happened. So thank you for a wonderful conversation. But before we let you go, we're going to ask some questions that we like to ask all of our guests to get to know you a little bit better as people, not just lawyers. So tell us something interesting or unusual about yourselves that is completely outside of your professional life. Jessica, you go first.
Okay. My favorite fun fact for folks that don't know me is that I'm a mom of 5, ages 16, 15, 12, 10, and 3. 3 girls and 2 boys.
I don't know how you manage that. I'm just fostering a dog in my house right now. I feel like with the dog and my cat, I'm already moving like an army. Like wherever I go, they go.
Okay, Alex, this is not a competition, but can you top that?
No, absolutely not. But when I was on OCA previously, I had just adopted a rescue dog named Walter, and I talked about that on the podcast. So I figured this would be a good opportunity to give a Walter update. 5 years in, Walter's a great dog. Our family calls him the world's hungriest dog because he's not only, begging for dinner 2 hours before it's due, but he also will eat anything left around the house, including one time when I was at a trial in Seattle. I got a call from my wife that Walter had opened an Amazon box and eaten 60 packages of fruit snacks. He opened the Amazon box, he opened the fruit snacks box and the individual packages of the fruit snacks and ate the fruit snacks out of them. And he was okay. So that's, he's doing great. Also, important update, and for those of you on YouTube, I'm holding up a picture of Walter here. Walter got second place in a beauty contest. So just like the Monopoly prize, he's received a lot of accolades.
Wow, must be all those fruit snacks. So good.
That's right.
So good for the fur.
That's right.
And finally, we're going to now play a little game we call The Curious Hat.
And now it's time for The Curious Hat.
The rules of the game could not be more simple. I'll ask Anora to select a random surprise question from our metaphorical hat. So take it away, Anora.
Jessica, you are going to reveal, is there any popular food item that you dislike intensely?
Cucumbers.
Just cucumbers or any, particular ways how it's prepared?
Any cucumber. Nope, I do not eat them.
That is a little unusual. Alex, when you travel, what are some of your favorite packing tips and techniques?
The most important tip for me is that I pack by myself. So I have to go in my room, and my wife and kids are not allowed in during the 20 minutes while I'm packing, because otherwise I tend to forget socks or some other key item. And so just having the concentration to do that. And I will also add that my number one food item that I dislike is pickles, and that is a cucumber-specific food. So Jessica and I have that in common.
Wow, I'd like to know what cucumbers did to you guys. Anyway, thank you both so much for a fantastic episode. Thank you, Anora. Thank you to listeners, and tune in to next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.